Welcome back to the Bible Explained. The question is, how to dismiss a traffic violation case? And what does it have to do with the Word of God? Now, many people are asking this question around the United States, so allow me to provide some assistance. Let's go over to 1 Timothy chapter 1, verse 8 through 11. It says, "But we know that the law is good, if a man use it lawfully, knowing this, that the law is not made for a righteous man, but for the lawless and disobedient, for the ungodly and for sinners, for unholy and profane, for murderers of fathers and murderers of mothers, for manslayers, for whoremongers, for them that defile themselves with mankind, for men stealers, for liars, for perjured persons, and if there be any other thing that is contrary to sound doctrine, according to the glorious gospel of the blessed God, which was committed to my trust." It's clear the law is made for the unrighteous man, not towards those who are convicted of victimless crimes, but more importantly, blessed are those who are committed to his trust. Literally, his trust, or trust indenture, which means a contract. Now, it is up to you to declare to be a part of his trust or not, which means to have your express trust connected with biblical treaty law. This is what the officials respect. When we look at the origin of the Constitution, where your God-given rights are protected, it did not start with the U.S. Constitution in 1789. It began with the Articles of Association in 1774, then the Declaration of Independence in 1776, then the treaty with the Delawares in 1778, followed by the Articles of Confederation in 1781, then the Republic Corporate USA Constitution in 1787, and finally it was changed to a Democratic Corporate USA Constitution 2 years later in 1789. But all of this comes from biblical treaties. Your officials in your state / country are indeed trustees who swore to manage the state constitution, trust indenture on behalf of you, the beneficiary. All you have to do is express it in writing and record it in their books. Now, let's say you received a traffic citation for running a stop sign or a red light, or you weren't wearing a seatbelt. Basically, a victimless crime when there is no injured party. An officer hands you a citation which summons you to appear in court. Well, at the very beginning of this confrontation, this case is already geared for dismissal. Before we get into that, everyone needs to be aware of what's called the Do Not Stop, Do Not Detain list. It's the list that your electors are on for constitutional protection. It starts with filing an injunctive relief, which I learned from my mentor, Jonah Bay, who still teaches law and wealth practices. Now, the injunctive relief, it prevents officers from pulling you over if they have time to run your plates, and even if they don't have time, they simply take your ID, and upon entering the name that's on the ID into their computer, it will inform them to let you go if you did not harm anyone. Now, what is an injunctive relief? An injunctive relief, also known as an injunction, is a remedy which restrains a party from doing certain acts or requires a party to act in a certain way. It is generally only available when there is no other remedy at law, and irreparable harm will result if the relief is not granted. The purpose of this form of relief is to prevent future wrong. Now, to activate the injunctive relief, this means you will need to be familiar with and study your state's constitution, any one document existing prior to 1933, and you must file it 3 times as first notice, notice to cure, and default to your state's constitutional officers. In my country, California, looking at my 1849 Constitution, I would have to file the injunction with officers such as the county sheriff, aka the Sherifian who wears the seal of David or the seal of Solomon across their heart, the governor, the Supreme Chief Justice, and the Attorney General. So serving 3 times will solidify an administrative process per the Administrative Procedures Act. If you want to learn the step-by-step process on filing the injunction in your state, you must head over to the Bible Explained Patreon page. If you go down, go to the senior class, and here you will learn how to file the state injunction, what to look for in your state constitution. It's also going to have the template for the style of process, and that's very important. The style of process is how it activates and places the injunctive relief on command, so to speak. Now, I will be adding each state's injunction so that whatever state you're in or whatever state you're going to travel to protect yourself on the road, you will be able to come here and obtain that, so that way it's an already done for you process. Okay, so be sure to look out for future videos and future emails or statements when that is complete. Now, I have a short recording of what happens when you get pulled over by the police under the injunction. It's not much, but it went exactly as it should. They just leave you alone. Why? Because I and many others have expressed in their system that we are in God's trust. And if you are in Him, who can be before you? It's time that we start applying His word instead of just reading the words every Sunday. So here's my recording of being pulled over for driving with expired tags.
All right, bud. Here you go.
All right.
Drive safe.
Thank you. Injunction. That's it. Nice and simple. I gave the officer my ID. He took it. He went back to his car to plug in the information to see if there is anything against me as far as a warrant or judgments, liens, anything of that nature. And it said, do not stop, do not detain. He came back. He didn't let me know that I was on that list. Of course, they're not going to do that. But as you see, he didn't mention the tags. He didn't mention anything. He gave me my ID back and I was on my way. He said, have a nice day, drive safely. That is what you want. That is the respect you want from all officers and all sheriff's departments. Okay, so now with each injunction, you can place up to 4 vehicles per document. So why not protect your family? Not just yourself. Why not have a mother's son return home to her opposed to finding bad news for a political agenda? Now, if officers want to be rude, there is no remedy against that, but it's our responsibility to respect the officer at all times, no matter what. So now let's go over how to dismiss a traffic violation. First, you're going to title the document a motion for discovery. Before you pay anything for any citation, you're going to want proof of claim, and you have the right to ask for it. And this is for a traffic violation, even if there is a warrant out for you because you failed to appear to a recent hearing or the first hearing. It does not matter. You can still ask for a motion for discovery. And the first thing that you want to point out in your document is you must have the judge take judicial notice of your state constitution under Rule 201. Let's take a look at that. This is the Federal Rules of Evidence, Rule 201. Taking notice. The court may take judicial notice on its own, or number 2, must take judicial notice if a party requests it and the court is supplied with the necessary information. D. Timing. The court may take judicial notice at any stage of the proceeding. E. Opportunity to be heard. On timely request, a party is entitled to be heard on the propriety of taking judicial notice and the nature of the fact to be noticed. If the court takes judicial notice before notifying a party, the party on request is still entitled to be heard. And this goes right in line with the trust indenture. The court judge gave an oath to protect, which in my country, that's California, that would be Section 3 of the Declaration of Rights. Go back to the Declaration of Rights here. Section 3. The right of trial by jury shall be secured to all and remain inviolate forever. But a jury trial may be waived by the parties in all civil cases in the manner to be prescribed by law. You see, your right for a trial by jury can only be waived if you appeared and said you didn't want it, or you failed to appear. So this is why you must stay away from what's called latches. And latches means they have you in their jurisdiction, you acquiesced, and you didn't follow the rules of the court. You want to make sure you stay in honor. And so this is the first point that I would want the court to take judicial notice of, right here, my right for a trial by jury. The second point is Section 2. All political power is inherent in the people. Government is instituted for the protection, security, and benefit of the people, and they have the right to alter or reform the same whenever the public good may require it. We're going to go through this step by step so you can see at the end how exactly you're going to draft this motion for discovery, get it on the record, and get the case dismissed. This is for anything in regards to a victimless crime where you have not injured anyone. So stay through the entire video so you can see exactly how to do this. The third point is referenced in, I'm going to go to section 19. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable seizures and searches shall not be violated, and no warrant shall issue but on probable cause, supported by oath or affirmation, particularly describing the place to be searched and the persons and things to be seized. And finally, point number 4, I'm going to mention section 16 here, that no bill of attainder, ex post facto law, or law impairing the obligation of contracts shall ever be passed. And this is an important one. If you have an express trust with the terms already listed inside of it, and it is properly recorded in their records, that means their rules that exist after the biblical treaties and the documents that created the Constitution cannot usurp your contract. If they did, that means that they're creating laws which would impair the obligation of your contract, which they cannot do. So what are they doing here? They have all these statutes and codes on the citation that's considered an ex post facto law. It's being applied retroactively to this Constitution. This Constitution came in 1849, and these codes and statutes came about in 1970s and whatever. That's after, and they're taking that to be applied retroactively, which is unconstitutional. So those are the 4 points that you want to raise. Now, the next thing you have to do is to express those 4 points under a subcategory titled affidavit of denial. Okay, and that is going to begin with, and quote, I, last name, first name, middle name, a Kentuckian or Pennsylvanian, depending on the country you were born in, and you need to check the 2016 GPO style manual that is going to be in the description below so that you can see what exactly is your nationality. What do these officials actually respect when it comes to stating who you are? Let's look up the 2016 GPO style manual. If you go to page 95, it talks about nationalities. So whichever state you were born in, this is what you would refer to yourself as. For me, it's Californian, Michigan, Michiganian. We have Missourian. So wherever you were born, this is what you would select. So it would be I, last name, first name, middle name, a Kentuckian, and trust protector of blank express trust. This is where you're going to give yourself a powerful Latin trust name. Let's check out a list of Latin names for your trust. These are all options. You can use them. Business incidental, incidentalia negoti. We have Cura. You can have the Cura Express Trust. I believe one of my students has already selected this. But go through it and pick a term that best is familiar with yourself, your line of work, of what feels good to you. Master of the case. Once you become proficient in court law as your own private lawyer, maybe you want to call your trust the Dominus Litis Express Trust. Okay? So pick one of these names, and as you go down, you'll see that this is all related to ecclesiastical law as well. Like I said, law is common law, and it comes from biblical treaties. So you want to pick a powerful trust name. So after that, you're going to state that you hereby rebut, point for point, each statement in the summons or warrant titled whatever it is or statute they've used. This is where you deny every fact or claim against you. Now, when complete, you sign and date under 28 U.S.C. 1746, Section 1. And what is this? This is basically the unsworn declaration under penalty of perjury. This is what allows you to properly serve documents without having to get a notary. Okay? Some documents you would need a notary and some you will not. Under paragraph 1, you are swearing under penalty of perjury without the United States. This is what you want. 2, if you don't say this, then you're automatically going to be placed under their jurisdiction within the United States. As you see, they're showing you the difference between United States of America or just plain old United States and every single territory, possession, or commonwealth, such as the U.S. Virgin Islands, the Commonwealth of Massachusetts, states like that. That's all considered the District of Columbia. So you want to remain under paragraph 1, where you're under the Republic of USA. The next subcategory is titled Material of Facts. And this is where you support your previous 4 points. The first point was right to a trial by jury. Because the court moved against you without giving you a trial by jury, and you request to be heard with the right to face your accuser. The second point was that all power is inherent in the people, and you accept the Legislative Assembly as trustee of the trust indenture for your benefit as a beneficiary. And point 3, the officer who issued a summons on the side of a public easement, or in other words, on the side of the road, without an affidavit of complaint approved by the clerk of court or judge attached to the summons or warrant, you request a certified copy of that complaint from your accuser stating who you injured. You see, this goes back to Section 19. It says, only a warrant or summons can be issued when it is supported by oath of affirmation. That means an affidavit of complaint. They're giving you a citation on the side of the road without the affidavit of complaint under penalty of perjury. The rule is, if you're going to sue somebody or bring them to court, you first must file an affidavit of complaint. It gets approved by the clerk of court. They give you a warrant or a summons, and then you properly serve them. You cannot serve someone on the side of the road at the same time you're the one who's complaining, or you're the alleged accuser. That's not due process. And the fourth point, no bill of attainder, is said here in number 16, no bill of attainder or ex post facto law. What is a no bill of attainder? It is a legislative act that imposes punishment without a trial. And that is exactly what they're trying to do. Force you to come into the hearing and just elect to see what you can pay right there on the spot for a settlement, or if you don't show, then they're going to move forward with a warrant for an even higher fine. And you never had a trial. And what is ex post facto? Ex post facto is a law that retroactively alters a defendant's rights, especially by criminalizing and imposing punishment for an act that was not criminal or punishable at the time it was committed. Do you see what they're doing? They are using codes and statutes, which are laws being applied retroactively to the Articles of Confederation and the constitutions prior to 1933. And that's unconstitutional. And finally, you must end your motion for discovery with a prayer for relief. And you're going to request that if no trial by jury is granted or no evidence of an affidavit of complaint attached to the summons or warrant, you move the court for dismissal based on Rule 12 in your state's rules, which comes from the Federal Rules of Civil Procedures, and that's Rule 12. Let's look at that here. Under defenses and objections. Rule 12, defenses and objections. When and how presented, motion for judgment on the pleadings, consolidating motions, waiving defenses, pretrial hearings. This is how you end the case. So let's go ahead and read B. A party must serve an answer to a counterclaim or cross-claim within 21 days after being served with the pleading that states the counterclaim or cross-claim, and that is you. If they are serving you and they are bringing you into court, your motion for discovery is considered the counterclaim or cross-claim. So when you file it, they have 21 days to answer. This is why as soon as you get the ticket, you must put in your motion for discovery the next day, as soon as possible, so that they have enough time before the hearing to answer. So that way, what happens is, if you file this right on time, they may do one of three things: change the case number, move your hearing to a further date in the latter of the year, and when they do that, if you try to go on the website and pull up your case number just to see if it's still on, you can't even find the case number. That means they dismissed it, and they would rather you not even come into court to state your arguments, because most likely it can become precedence, and they are really afraid of everyone else in line who's behind you trying to make their plea. They're going to hear what you're doing, and they're going to understand, oh, okay, that's how I get out of this situation. They do not want that to happen. They do not want what you're writing to be said verbally on the record, because then anyone can pull it. So in third, they'll just dismiss the case. Okay, so you make sure that you serve the motion for discovery in time. Now let's go down to subsection B. This is what you're going to state in your prayer for relief if none of those two items that you request is given. Remember, trial by jury and an affidavit of complaint from your accuser. If you don't get that, then you're going to dismiss the case based on the following reasons. Number 1, motion to dismiss for lack of subject matter jurisdiction, where the express trust can only be heard in equity. The express trust is under common law, which can only be heard in equity court or chancery court, not the Administrative Procedures Act that they always are operating under. That's civil law. So they don't have subject matter jurisdiction. Number 2, motion to dismiss for lack of personal jurisdiction, where no state shall interfere with the obligation of contracts such as the express trust. Number 3, motion to dismiss for improper venue, and this goes right along with number 1. Number 4, motion to dismiss for insufficient process, where the officer violated his oath to discharge his duties and maintain constitutional court procedure by failing to submit his affidavit of complaint to the court before delivering a summons. Okay. Number 5, motion to dismiss for insufficient service of process, where the officer violated constitutional law in serving a summons without the clerk of court approval to issue. And finally, number 6, motion to dismiss for failure to state a claim upon which relief can be granted, with attempts to issue bills of attainder, fines, and impositions without a trial by jury, or motion to be heard to face your accuser. And there's no need to mention number 7. The only time we would mention number 7 if, let's say, you entered into a 5.1 constitutional challenge where you're trying to get the Attorney General to assist you in stating, hey, why are they allowed to impose these fines and fees or citations and statutes against me when the Constitution says that they can't? Please, Attorney General, assist me in the constitutionality of what the court is doing. And if the court fails to bring in the Attorney General because you've asked for it under 5.1, then that is when you will state failure to join a party. Okay? And that is it. That is how you remove a traffic violation. Do you see how they take advantage and get away with fraud? It's because we are not in our right position to contest them. And so at the end of your motion of discovery, after you've mentioned your prayer of relief, you're going to end it off with another unsworn declaration statement from 28 U.S.C. 1746, paragraph 1, and then you're going to sign and date. Now, you must mail this motion for discovery with a proof of service. And that proof of service is going to be served to the clerk of court, the sheriff, the attending judge, and the state attorney general. And so when you go to court, you stick to what you have written. Do not change a word. Do not say anything different opposed to what is on the document that you have served. Don't forget to get your injunction done, because that will keep you out of court. So protect yourself and your family. File the injunctive relief and prosper. If you'd like me to file the injunction for you, protecting you, your property, and your family's property, give me a call at 689-244-0825, or you can go to the Patreon site, the Bible Explained. The link will be in the description, and you can check out the videos on the injunction to see how to get it done without missing any steps for your state. I hope this was useful to you. Take care, and I will see you in the next one.